Hello guys, Assalamu alaikum. My name is Afaq Ahmad Khan and today we will study the chapter Occupiers Liability. It's page number 169 of Tort Module Guide and it's also known as Defective Premises. The chapter name is Occupiers Liability. Before diving into the chapter, let's first look that previously we studied the chapter of trespass to person and land, and we also checked that whether a problem is examined from it or not. And almost in each past paper of 20 from 2018 till 2024 May exam, the problem was examined by the examiners regarding the topic of trespass to land and trespass to person. And the most important between those two was trespass to person. Now let's check about occupiers liability in 2022 paper zone A and whether is it examined and is it important or not. Part A is article again. Okay, moving on. Okay, this is not. Again, this is the trespass to person problem. Check. This question deals with the occupier's liability. Thus, it might be examined in our next exam. Now going towards 2023 past paper. Okay, check. This is regarding trespass to person. We studied that already and did a problem on it. Again, occupiers liability question. Thus, it is an important chapter to cover. If you cover this and the previous chapter of trespass, you will be able to cover at least two problems easily. Now, going into details of the occupier's liability, by the terms occupier and the liability, who is an occupier? Occupier is a person who controls or occupies some premises. The premises might be house, the premises might be office or restaurant or a cafe. Thus, a person who owns, who occupies or controls the premises is known as the occupier of that premises. Now, the occupier's liability, the person in control liability, the liability of the person in control towards the visitors and non-visitors. The non-visitors include unlawful visitors who are known as trespassers. Now, what kind of liability? Liability means that, for example, a person visits a cafe. Okay, I have an example down below there. That imagine a grocery store owner. A customer enters into the store. Okay, highlight this. And there's a spill of water on the floor that hasn't been cleaned up. So what is there? Spill of water on the floor that hasn't been cleaned up by the owner or the occupier. Or marked with a warning sign, and there was no warning sign there placed. The customer slips on the water, falls and injures themselves. Now, due to the state of the premises, not because of the customer actions, but due to the state of premises. The state of premises means that the water was on the floor due to the condition of the premises or due to the state of premises. The customer slipped and got injuries. In this case, the store owner, who is the occupier of that store, would be liable for the customer injuries because they failed to ensure that the premises is safe. Just because they didn't clean that space and breaching their duty of care, they would be liable for occupier's liability. Now, there is an important question regarding it, that what does it specifically mean? It is the duty of care owed by those who occupy or control premises to individuals who come onto their property. Thus, a person who is controlling or occupying a premise, he has the liability towards, let me continue it. He has the liability towards those individuals who come into their property, either lawful visitors or non-lawful visitors. Moreover, keep in mind that liability will not be towards when a person actions give some injury to another person. Liability will be only in those circumstances where the injury to the person has been caused by the state of the premises or by the anything which is placed on the premises which caused injury to them. In relation to this, when a person's action or the person occupying the land or the person occupying the house, his action causes injuries, then there will be no liability of occupier's liability crime. Okay, So the occupier's liability is only applicable on those circumstances where the injury is caused just because of the state of the premises. Okay, like in the above example, below example, it was the state of premises, like it was the malfunction of premises in which water was put on the floor and it wasn't cleaned up. Thus, the customer slipped, and thus he would be liable for occupier liability. Here, there was no the owner's action involved. It was due to the state of premises due to which the injury occurred. Thus, occupier's liability apply here. Okay. Now, there are two types of acts of occupier's liability. We have number first 1971 Act. Okay. And the second one is 1984 Act. In 1971 Act, we deal with the lawful visitors. We will study in detail later on that who are the lawful visitors. Okay. And in 1984 Act, we study the duty of to unlawful visitors. Simply, in the first act, 1957, we studied the duty of to lawful visitors, and a second, unlawful visitors. Who might be the unlawful visitors? We will study in detail later. Now, study this, that a person who suffers harm outside the premises, which was caused by something on the defendant premises, will not be able to claim in occupier's liability. Okay, this is a simple thing. At first, we studied that if the injury has been caused by the defendant actions, no liability. If it is caused by the state premises, liability. However, if this harm has been suffered by a thing which is outside the premises, then there will be no liability of occupier's liability just because it was outside the premises. The only liability will which occur in the circumstances that when injury has been occurred due to the state premises. Okay. Moving on into our 1957 Act in detail, as we already studied that 1957 Act, we have two acts, 1957 and 1984. The 1957 deals with the lawful visitors and 1984 deals with the non-lawful visitors. So first of all, we will study 1957 Act, which is dealing with lawful visitors. According to Section 1 of OLA 1957, OLA stands for Occupiers Liability. Okay. Act. This law codified the common law rules which regulates the duty important of an occupier of the premises towards visitors. Now, here, visitors are known as lawful visitors. Okay. Simple visitors are lawful visitors in relation to injury or damage caused by the danger arising from the state of premises. As we already wrote the definition, so according to Section 1 of OLA 1957, it tells us about the rules which regulate the duty of an occupier, the duty of care of an occupier towards the visitor in relation to any injury or damage caused by the state of the premises arising due to it. Okay. Then we have a case of Ogo versus Taylor. Please note down this case. If the danger which caused the injury was caused by the defendant, here you might write defendant actions, rather than the state of premises, hence the liability will be under negligence than not OLA. It simply states that when the injury caused to the visitor is done by the defendant actions, thus there will be no liability under Occupiers Liability Act. However, if the injury has been caused to the visitor due to the state of premises, due to malfunction of anything in the house or an office or the premise, then it will be dealt with Occupiers Liability Act. Okay. Now, the first question which comes on to mind is that the first step of solving a problem is that what is premises? Okay, which place can be occupied and which place amounts to be a premise. So coming towards premise, let me make it up. Okay, premise is dealt under Section 1, subsection 3, para A. Okay, this is that which deals with the premise. Now, the question is that what can be occupied? And the law is that the injury must be in premises. If the injury has been caused outside the premises, then there will be no occupiers liability crime. What can be occupied? Anything movable, number first, or a fixed structure, including any vessel, vehicle, aircraft, houses, offices, factories, schools are in the category of fixed and movable structure and thus amount to premises. So this clearly tells that what amounts to premise. So first of all, by solving a problem, you must look that whether the place where the injury has been occurred amount to premise or not. If it is a house, then it you should state that according to the above definition, it fits in the definition and it is included in the category of the definition of movable and fixed structure. Thus, it is a premises and the injury has occurred in the premise. Okay. We have a case of Wheeler versus Copas, and it tells us that a ladder was held to come within the definition. Okay. A ladder was held under the definition. Moving on our to next step, which is regarding the occupier. Number first, we studied that what is premise, which things include in premise. A ladder includes in premise, a house includes in premise. Okay. Then now studies that who is an occupier of the place, who is the occupier in the control of the place. So occupier liabilities, the person who is an occupier or who is an occupier is dealt under section 1 subsection 2 of OLA 1957. Okay, please note this. Now we have two cases here. One case here. The case name is Wheat versus Lacon. You must mention this case in your problem. This is the one of the most important case to get marks for the occupiers. Who is an occupier section answer. According to this case, an occupier is any person with sufficient degree of control over the premises. In other words, person who is in actual possession and physical control of premises. Thus, it gives us three categories. Number first, a person having sufficient control over the premises. Okay. It's our first category. A person who is having control over the house, who is control of the office, he is an occupier of that place. Secondly, a person who is in actual possession of it. Again, it's the same. And thirdly, a person who is in control, physical control of that place. Thus, it has three categories this case has given us. In order to establish who is an occupier, we should use the case of Wheat versus Lacon, 1966. Okay. And in that, we should write that according to the above definition, a person is an occupier just because he was having control over the premise, as he was owner of the land and he was living there habitually and frequently. Okay. Then secondly, according to the Defective Premises Act 1972, landowners with their property rented are still considered as occupiers, provided that the landowner is obliged to make repairs on the terms. This deals with the tenancy agreement. For example, there is a landowner, he has given his house on rent to some people. However, it's in the agreement, there is a term that states that the landowner has to make repairs in the house. Thus, in this state, the landowner will also be regarded as occupier of that house. Okay, just because of the fact that the property is rented does not mean that he is not an occupier. There is a term added in the tenancy agreement which means that he has to make repairs in the house. Thus, the making repairs makes him as occupier, and it is told by Defective Premises Act 1972. Now, firstly, we studied that what is premises. Okay, definition we have done. Ogu versus Taylor case has been done. Then we studied that what is premises. We studied that anything movable or fixed structure, houses, aircrafts, offices, amount to premises. Then we studied the case of Wheeler versus Copas, 1981. Moving on, we studied that who is an occupier under section 1 subsection 2 of OLA 1957. We studied the case of Wheat versus Lacon 1966. We studied that a person having control over the land or the premise, a person having actual possession or physical control of the premises is an occupier of that place. Then we studied that if a person has given his home on rent and under the tenancy agreement, he has to make repairs, then the owner will also be regarded as an occupier of that place. Moving on to our third factor, which is lawful visitor. As we studied that 1957 deals with the lawful visitors, now we will check whether the person in the problem question is a lawful visitor or not. Under this section, visitors includes licensees or invitees. If a person is having a license to move into a place or come into a place, enter a home, that license could be impliedly or expressly, then he would be considered as a visitor. Studying the case of Lowry versus Walker, A person could enter the premise with the owner impliedly giving permission, even if no express permission is granted. Like our children have the implied permission, they are lawful visitors. Like a postman has implied permission, he has no express permission granted. However, according to the law of the case, a postman has the implied permission, thus he would be considered as a lawful visitor. Moving on to section 2 subsection 6 of OLA 1957, it deals with the police officers and firefighters. And basically, this states that the category of police officers and firefighters should be regarded as lawful visitors just because they have the legal right, and they have the legal right to enter the occupier's premises with or without permission. Thus, they would be regarded as lawful visitors under sections 2 subsection 6 of OLA 1957. Then we have section 3 subsection 1 and section 5 subsection 1 of OLA 1957, which tells us that provides for entry as a visitor in pursuance of a contract. For example, a contract has been done between an owner and another person who is doing painting in the house. Thus, the painter has the contract and he would be regarded as a lawful visitors under section 3 subsection 1 and 5 subsection 1. Okay, as he has done a contract with the owner, the occupier of the premises, to make paintings. So under this contract, he would be regarded as a lawful visitor. Keep this important point in mind. I have highlighted this, that children may be treated as lawful visitors if there was any alluring thing on the land for the children to play on. Now, this state clearly means that, okay, for example, there is a kid or a child who comes to your garden and you have planted beautiful flowers in the garden. Okay, now whether the child or the kid would be regarded as a lawful visitor or as a trespasser just because he was having no license and he was not an invitee. The court has stated that when there is an attractive thing or alluring thing in your land and a child comes for there in order to play, then in that circumstances you have to deal with children as lawful visitors, just in the sense that you have invited them onto their land. Okay, please note this. Now, after seeing that who is an occupier, what are premises, who is a lawful visitor, now the turn is about that what is the liability of an occupier towards the visitors. Okay, so section 2 subsection 2 OLA 1957 tells us that the premises which you are occupying must be safe for the visitors, and you should take reasonable steps in order to make this safety. Okay, so number first factor is duty of care. Section 2 subsection 1 OLA 1957 tells us that every occupier has a duty of care towards the visitor. You should be there in order to ensure that the premise or the state of premises and the activities conducted on that premises are safe, and it will not put the life of visitors in danger. Coming towards the case of Cunningham, let me highlight this. It was held that the duty to ensure that the state of premises and the activities conducted on the premises, even by a third party, is such that it will not put visitors in the risk of danger. This clearly means that the occupier has the duty of care to every person who is a visitor in order to check and ensure that the state of premises on which he is coming is safe and sound, whether the activities conducted on the state of premises, even by a third party, must be safe, and it should not put the life in danger of the visitor. Okay. Now, moving on to the reasonable steps. Number second factor in the duty liability. The duty as taking reasonable steps in ensuring that the visitor is safe and using the premises for its own permitted purpose. For example, there is a swimming pool in your house and you have made a party for your kid who is inviting his friends. Okay, now you have the duty to put signboards or take any reasonable steps to avoid any person who might drown in the swimming pool. Okay, these are the reasonable steps to be taken. We should study the case of Darby versus National Trust. This case deals that it held that the absence of signs prohibiting swimming in a lake did not fall below the reasonable standard of care, since the danger arising from it is obvious to any reasonable person. Okay, then for example, apply this case to a situation where you have invited kids to a party in your home and you have a swimming pool and you haven't made any you haven't took any reasonable steps. In that situation, you would be liable. However, in the lake, the person or the kids do not visit alone. They are accompanied by their parents. Thus, their parents have the duty to ensure that the kids are safe. Okay. Moving to the case of Redstone, it states that a regular inspections as opposed to a minute by minute inspections was sufficient and did not fall under the reasonable standard of care. Kindly note this is important for Power questions. I assure this. We have another case of G4S care. Let's check this case also. The failure of the defendant to act promptly despite the knowledge of the claimant's vulnerability fell below the reasonable standard of care. Okay. When a person who knows that a child might drown in a swimming pool and he knows that the person is vulnerable to this or etc example, and he fails to act or he does not act despite the knowledge of that fact, thus he has the duty and he will be liable under occupiers liability just because the ratio of his acting falls below the reasonable standard of care. And in situation where it falls after or ensures that he has done a standard of care, then there will be no liability. Okay. Going towards duty of care towards children, this is the most important topic, and it from problem point of view, and is dealt by examiners in both situations. Okay, this is the most important one. Let me make it. Wait a minute. Let me make it here to the mid. Okay. It provides that since children are less careful than adults, the occupier needs to take when they are on the premises. In this situation, when a children, as I gave an example of the swimming pool, just by making signboards when kids enter into your home for a party, does not mean that you have taken a reasonable standard of care. You must install some other things which should stop the children to jump into the swimming pool. Okay, this is known as the duty of care. You must have more duty of care. You must be more careful than adults just because they are vulnerable children. Coming to the case of Glasgow Cop versus Taylor, a 5-year-old child was drawn to the trespass due to something attractive. The court held that the defendant was liable by applying the element doctrine. As we studied here, there was a case of element. Look at this important point. As I said, that it will be dealt in exam point of view, and it has also been dealt in a case of Glasgow, that when there is an element or something attractive on your land, the child would be regarded as a visitor and you would be liable for anything which has happened or any injury caused to him due to a state of premises on your premise. Coming to the case of Phipps 1955, Devlin J. placed the responsibility for small children primarily on their parents and concluded that both parents and occupiers should react reasonably. This case, you should write two-way arguments in it. You should check whether the parents are accompanied or not. Okay. And you should also check that you must take reasonable steps in order to prevent that child from doing anything which causes an injury due to a state of premises on your place. Okay. So the responsibility lies on both people. If the according to the facts, if the occupier believes that his parents are taking care of the children, then there will be no liability just because he has reasonably thought that the parents are taking care of the small children. Bond Leisure versus 2009, the occupier will not be liable if there was nothing that he could reasonably have to done such injury. Simple thing that if I something injury or something was happening to an person or a lawful visitor in my premise and I couldn't take any step and or no reasonable step could be taken on behalf of the occupier, then there will be no liability for such an injury caused to the lawful visitor. Now coming towards our next factor, which is person exercising the duty. For example, a person is having a job and he is doing some work on your land as their job. So now here in this place, any occupier of the premise reasonably believes or expects from that person any precautions which is related to their job. Okay. And a person occupier reasonably also believes that the person who is performing their job might take precautions, as there is this is their job and they might know that which precautions should be taken. As we have the Rolls versus Nathan case, it was held that since the injury caused was the common risk of the job and was known to the claimant, the occupier did not breach his duty and was not expected to protect such danger. This clearly tells us that when occupier believes that the person who is performing the job, he must know that what precautions should I take and to prevent any special risk. So there will be no liability on the occupier and he will not be breaching his duty, as he expected that the person who is occupying or who is doing his job on the land or the premise, he must take any precautions, and he would have taken any precautions for that, as it is his duty and he is more aware than me about the precautions and danger of that duty. Another case we have Augo versus Taylor again. Here in the second case, it tells us that the place where occupier will be liable. The occupier was liable for the steam injuries caused to the firefighters is the risk was extraordinary in nature and cannot be said as a special risk that ordinarily arise. For example, if the risk of the job is not the simple risk which occurs in that job, and it's an extraordinary in nature, which is more than special risk, then the occupier will be liable for the injuries caused to the lawful visitor. Okay, so two types of situations. If the risk is special, no liability. If the risk is extraordinary in nature, there will be liability. Now coming towards independent contractors, it provides that the occupier will be liable for any damage caused to the visitor due to any faulty execution by an independent contractor. Okay, now it tells us that a situation when occupier will be liable for any damage caused to the visitor due to any faulty execution by any independent contractor. This means that occupier has the liability and occupier has the responsibility to check whether the independent contractor he hired on his premise is competent contractor. And number first, is he a competent contractor? Number second, is he working? He should ensure that the work he is doing is done properly. These are the two things which the occupier must be checked. And if he has checked it reasonably, then there will be no liability. As according to the Hasseldine case, note this down. Occupier have to check their work. However, if the work is of technical nature, then they may not have to check it themselves. Moving on to the Woodward 1945, it tells us that if there is no specialist knowledge required, occupier should have checked or the danger could have been prevented. It tells us that when occupier there is no special knowledge required for the occupier to check whether the work being done is done properly, then the occupier has the responsibility and would be liable in circumstances the danger could have been prevented. For example, I give you an example of let me open the book. There is an important case in the book, the facts of which are very clear and tells us about this. Okay, let me check that whether it is on which number page. It was a very important case. Okay, this is very important. Please listen the facts. A child slipped on an icy step at a school and was injured. The fact states us that when there was a child who slipped on an icy step in the school and was injured. The step had been left in a dangerous condition by a cleaner. Now, in this situation, we have an independent contractor who is a cleaner, okay? And even assuming that a cleaner was an independent contractor, the defendants were liable. since there was no technical knowledge required to check the cleaning of a step. It means that applying the Woodward case, there was a contractor, but there was no special knowledge required that whether the place is safe or not. Thus, the occupier will be liable just because of the reason that there was no extra technical knowledge required to clean that place so the children could be safe. Okay. Moving on to the case of Ferguson 1987. You can find these facts of Woodward 1945 on module guide, page 176, para number, it is para number 1, 2, para 2, and last fifth line. Okay. Woodward case, the name of the case is Woodward of the cleaner that child. Then we have Ferguson 1987, in which is why held that occupier should have taken reasonable steps to check and ensure that the contractor was competent and the work was done properly. This I had always studied with you that the occupier has two responsibility: to check whether the contractor is independent and competent, and whether the work he is doing is it proper or not. After checking that, then there will be no liability on occupier. Moving on into the defenses for visitors, which can take. Number first defense the occupier may rely on is the warning. He may state that I had placed a warning, and it was the place. Then the place was not reasonably safe. This states that the sufficient warning as to anger was given to the safe. This is not anger, this is danger. Or given to the visitor as to ensure his reasonable safety, the occupier will not be liable for any injury suffered. Okay, this clearly states that if the warning is placed, then there will be no liability. We have the case of Raimas. A mere notice of not warning will not be sufficient if the danger was unusually extreme. For example, if the danger is very, very, very extreme, then warning would not suffice. You must take some additional steps to stop a person from that. We have the case of Rolls Nathan. Let me check whether it is creating alternative paths to ensure safety. The place at your own risk. And the last defense he can use is the voluntary non-fit injuria, where the visitors ignore the dangers, ignore the warning, and ignore the risk, and despite knowing that there is a risk, the person enters into the premises. And now moving on into the Occupiers Liability 1984 towards the trespassers. Okay. In the first we studied about lawful visitors, now it is about trespassers. According to section 1, subsection 1 of OLA 1984, it states that occupier has the duty for the injuries caused to a trespasser due to the dangers which arose from the state. We stated that occupier has the duty to the person who is a lawful visitor due to the dangers which arose from the state premises. And second, 1984 stated that occupiers will be trespassers. Okay. Now the definition of premises will be same. The definition of occupier will be same. The third category will be who will be a trespasser. Now, according to section 1, subsection 1 of OLA 1984, it provides that 1984 Act applies to liability that does not fall. This is fall. Sorry, that does not fall under the 1957 Act. When you check that the person is not a lawful visitor, then a trespasser. We have the case of Anderson versus Woods. It was held that the party failure to comply with the notices were in place restrict entry in the premises will render him a trespasser. A place where a person has ignored that the place is restricted and he still enters that place, then he will be regarded as a trespasser. We have the case of Calgarth This states that the instances where it is clear to the reasonable person the entry is prohibited in certain areas, there is no need for the occupier to expressly state a prohibition. Now, it is reasonably known to a person that entering into for example, a place which is prohibited in certain conditions, and he still enters that place, so he would be regarded as a trespasser. Now, what would be the liability towards a trespasser? The section which deals with it is known as Section 1, subsection 3 of OLA 1984 deals with it. The first is duty of care. We have a case of British Railway Board where it is stated that an occupier owes a trespasser duty of care provided that the risk of danger and the trespasser presence is within the occupier knowledge. When an occupier knows that a trespasser is on my land, and he has the knowledge that he has entered the land or the premise, thus he has the duty of care, and he would be responsible for any dangers or injury caused to the trespasser. Now, there are three situations when the duty will be owed by an occupier towards a trespasser. Number first, when an occupier is unaware of the danger, he knows that there is a danger or have reasonable grounds that he was aware of the danger. Number second, he is aware of the reasonable grounds to believe that non-visitor is in the vicinity. The second tells us that he was aware that there is a non-lawful visitor, or he has the reasonable grounds to believe that there is a non-visitor. Non-visitor means trespasser. The third requirement is that risk is one against which all circumstances of case he may be reasonably expected to offer the non-visitor some protection. When he knows that there is some risk and I should offer some protection to that person. Now, the defenses apply would be the same as for the 1957 Act. The same defenses would apply for the warning and exclusion of liability, and non-fitting injury defense would be applied here also. So far as now, we have finished the chapter of occupiers liability, chapter 15. We studied the two acts, 1957 Act, which deals with the lawful visitors, and 1984 Act, which deals with the unlawful visitors. Then we also studied that injury must be caused by a state of premises, not by the action of the defendants on the premises. And when the injuries are caused outside the premises, then there will be no liability. The injury must be caused inside the premises on or the premises. Then we studied the Ogbo-Taylor case. First of all, we came to the premise that what is premise, and any house or office includes in premise. We studied the case of Wheeler. We stated that a ladder was held to come in within the definition. We also stated the occupier, that who is an occupier. We studied the Wheat versus Lacan case, which is the most important case, which tells us that a person having sufficient degree of control or possession or physical control of the premises will be considered as an occupier. Moving on, we studied that who is a lawful visitor. A person who can enter your land with an implied permission is a lawful visitor. A person having a license, a person who is an invitee. Then we studied the section 2, subsection 6 of OLA 1957, where we studied that police officers and firefighters will be regarded as a lawful visitors, as they have the legal right to enter your premise with or without your permission. We also studied that section 3, subsection 1 and 5, subsection 1 tells us that when a person has a contract made with the occupier, then he will be regarded as a lawful visitor. We also stated that if there are any attractive things present on your place and the child comes to play on it, then the child would be regarded as a lawful visitor, and the doctrine is known as allurement doctrine. Now we came into the liability towards the visitors. We studied the duty of care, to what duty of care should be taken, and reasonable steps must be taken to ensure the safety of the visitor. Moving on, we studied that what type of duty of care occupier owes towards the children. In this situation, the occupier must be more careful than adults for the children. And a person exercising a duty, here the occupier might believe that the person who is exercising his duty knows about the risk associated with his job. Moving on, we studied the independent contractors. Here we studied about the two things. Number first, that the occupier should check whether the contractor was competent, and second, the work he was doing, was it proper or not. If it was, the two factors are satisfied, then there will be no liability. Moving on, we started with the defense for visitors. We studied the warning defense, exclusion of liability defense, and voluntary non-fit injuria defense. And then we've moved on to 1954 for trespasser, as we studied now. In the next lecture, we will go towards the problem solving of this occupiers liability. We will solve the problem. There are two situations always in occupiers liability problem. Now, the first situation we deal with 1957 Act, and the second might deal with the 1984 Act. So we have two situations in one problem. One will be dealt with lawful visitor, and the second will be dealt with unlawful visitor. So kindly revise this lecture, and in the next lecture we will solve a problem. We will write a structure of it, and how we will tackle a problem question, and how easily we can grip on the facts. Thank you for watching the lecture. Thank you so much.